Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Syakinah binti Abdurrani. Today I will explain about the case of Datuk Muhammad Salim Fatih bin Fatidin against Nadiswaran anak lelaki Raja. This case was cited in High Court Kuala Lumpur by Judge of Amelia T. Abdullah on 27 April 2012. The plaintiff, a well-known businessman, filed a lawsuit against the defendant, a journalist, for making 2 defamatory remarks about him on tweet. According to the plaintiff, the defendant's comment could be viewed by anybody who entered his website, and he had thousands of followers of his tweets, including major business people, politicians, and media celebrities. Despite his solicited demands that the defendant cease and desist from publishing the defamatory statements and issue a full and unequivocal written apology and retraction of the statement, the plaintiff testified that the defendant had instead tweeted that the plaintiff was trying to intimidate him and that he, the defendant, loves the good battle and will take him on. According to the complaint, the defamatory allegation harmed his reputation and caused him great shame and suffering. He demanded general, aggravated, and exemplary damages as well as a complete and unambiguous public retraction and apology for the defamation and an order prohibiting the defendant, his servant, and agents from defaming him further. The defendant neglected to file and serve a defense, and he did not appear in court for the suit's trial. The issue of the case is whether the defendant's conduct deserves award of aggravated damages. In the court judgment stated that as the defendant did not provide a defense, he was presumed to have acknowledged each day and every allegation in the plaintiff's statement of claim. As a result, the court simply had to deal with the question of determining the amount of damages to be given to the plaintiff. Not only that, courts also see the conduct of the defendant from time of the libel. In a letter dated 30 December 2010, the plaintiff's attorney asked the defendant to stop publishing the first and second defamatory remarks and to issue a throughout the unambiguous apology and retraction. The plaintiff further stated his desire to file a lawsuit against the defendant for the defamatory comments. Not only that, the defendant failed to respond to the state letter, but he also made another comment in his Twitter page implying that he had no intention of ceasing and desisting. The court agrees with the plaintiff's skill counsel that the terms in the aforementioned statement will demonstrate the defendant's arrogance and contemptuous attitude towards the plaintiff's effort to resolve the situation. The absence of any attempt by the defendant to amend, retract, or give or publish an apology as has been considered by the court. These procedures, if taken, will have gone a long way toward lowering the amount of damages. Not only that, there are no retraction or apology in this case, but the defendant was actually preparing for a fight. This more than anything else would indicate a lack of intention to retract or apologies. On the contrary, the defendant's tweets are still available on his Twitter website as of the day of the hearing. This factor clearly lent to highest amount of damages. The court has duly considered all of the aforementioned factors and is of the opinion that aggravated damages can be granted in light of defendant's conduct in failing to make any apology and failing to withdraw the offending statement from his website, allowing the defamatory statement to continue to be published right up until the hearing date. In determining the amount of damages and aggravated damages to be given in this instance, the court took into account that the defendant is a journalist whose column Citizen's Net has a sizable readership. The defendant's column deals with public interest problems on a daily basis, which spark debate and consideration among his readers. His Twitter website, which has over 4,000 followers and a large number of casual visitors, will presumably receive a high volume of traffic. As a result, the court believed that the defendant should have exercised greater caution in his tweets, knowing full well that they might and would be viewed by a large number of people. Where he fails to take sufficient care with his posting and inadvertently injures someone with his defamatory remarks, he should be held accountable and liable to pay for it. Next, the court is left with no question that the plaintiff is a man of stature and significance in business both locally and regionally or internationally, as well as in society. As a result, the court has no qualms admitting that the plaintiff is a prominent person with a good reputation who occupies crucial position in society and industry, a person who is held in high regard and whose reputation will be substantially harmed by the defamatory allegation. As a consequence, depending on the stated law, the court finds no value in the defendant's contentions that because the plaintiff has not demonstrated the magnitude of his losses as a result of the defamatory comments, he should not be entitled to the damage request. In my opinion, Dato' Muhammad Salim Fatih has right to sue the defendant, that is seorang anak lelaki Rajah, for defamation. So, in this case, I refer to the case of Borneo Pasirian Berhad and another, and Sarawak Pasirian Berhad, that held that the company may claim for liable injuries its reputation in the way of its business. There is no need to prove special damage. There is two types of defamation which are libel and slander. So in this case, the defamation is libel, and Dato' Muhammad Salim Fatih doesn't need to prove any special damages. Next, section 499 of Penal Code Act 574 state that anyone who with words spoken or intent to be read or with visible signs of representation draw up or publishes an indictment against a person which intend to harm or knowing or having reason to believe that such imputation will damage that person's reputation and is also liable to fine of that person is said to defame that person. Libel action per se, which implies that a plaintiff does not need to establish any damages because the law presumes that when a person's reputation is harmed, some harm must occur. So based on the law and cases, the plaintiff can sue the defendant as the tweet that the defendant posts in his Twitter account can be seen to everyone, and the statement also can ruin the plaintiff's reputation as well-known businessman. The author of the defamatory words will be the party sued with. In this case, is the defendant, that is seorang anak lelaki Rajah. The defendant also did nothing when he was given a chance to delete the tweet, so that the netizen cannot see the tweet anymore. He also does not apologize to his act and even challenge the plaintiff. So the defendant failed in his defense as the statement is considered as libel. That's all. Thank you.